My name is Lara Unger. I'm a teaching and research assistant at the University of Graz. And today my presentation is going to be about the categories of offences listed in Annex D of the EIO Directive and their conformity with the principle of legality. And I want to state that this presentation is based on a corresponding paper that I wrote in cooperation with Professor Szepecz and Professor Maszawalski. So thank you for letting me present our findings today. First, I want to talk briefly about the significance of Annex D. So Annex D contains a list of 32 different offences for which the lack of double criminality doesn't constitute a non-recognition or non-constitution ground. If the issued EEO concerns one of those listed offences and if the offence is punishable in the issuing member state by a sentence for a maximum period of at least 3 years. This list of offences, which can also be found in various other legal acts concerning mutual legal assistance, was first introduced in the legislative procedure concerning the European arrest warrant. And there it was originally inspired by the annex of the Europol Convention that listed series of forms of international crime which Europol could deal with. And the list was so expansive because, of course, Europol's mandate was designed with expansion in mind. And this list was then adapted into the framework decision on the European arrest warrant. And when it came to the EIO Directive, the question of whether to include this list or not arose again. And as Professor Abeshnik already mentioned in his presentation, the Member States initiative did not include the lack of double criminality as a general recognition ground. It was only introduced by the Council during the readings because they wanted to avoid a regression in comparison to the existing MLA instruments. So therefore, the general non-recognition ground for the lack of double criminality was introduced in the EIO Directive, but the Council wanted the refusal ground to be specific and narrow, and therefore the limitation of the double criminality refusal ground for the serious offences listed in Annex D was introduced, and they just used the list that was already included in the European arrest warrant. The existing list is heavily criticized by academics and practitioners alike. The points of criticism include the lack of a system behind the seemingly random listing of offences, the multiple mention of very similar or identical offences, for example, both the offence of swindling and the offence of fraud is mentioned. Another point of criticism is that the offences contain a multitude of different offences within them, or at least some of them do. And the list has a quite extensive scope, and some offences display an inherent lack of a cross-border element. Those are basically just purely national offences. However, the biggest problem that I see with this list is its possible conflict with the principle of legality. The principle of legality, often expressed in its Latin form, nulum crimen sine lege, is one of the most important and basic principles of criminal law. The principle also includes the principle of legal certainty that demands law to be certain and precise so that the legal implications of one's actions can be foreseen, and it provides legal security and also prevents judicial arbitrariness. And because of the intensity of the encroachment of fundamental rights through criminal law, the standard for the principle of legality and also the principle of legal certainty is especially high in criminal law. The European Court of Justice already had to deal with the question of the conformity of the list with the principle of legality in the context of the European arrest warrant. The decision followed a reference for a preliminary ruling by the Belgian Court of Arbitration. And in this decision, the European Court of Justice stated that there is no violation of the principle of legality because the definitions of the offences follow from the law of the member states and especially from the law of the issuing member state anyway. And despite the question of the compatibility of this recourse to national law with the principle of mutual trust, that is the whole basis for this list, there are 3 different problem areas that the ECJ decision doesn't really touch on and that I want to go into detail in my presentation. The first problem area is that if there is no normative content provided by the EU, then the differences in definitions in the member states may vary to such an extent that there is no clear legal definition of the offense at all. This can be seen, for example, if you look at the offense murder and grievous bodily injury that is mentioned in Annex D, whereas murder per se is not problematic because of its universal definition. The category grievous bodily injury might be problematic from the viewpoint of the principle of legality, because the question here is what makes an injury grievous as opposed to only severe. In some countries, this distinction is done by court practice. In other countries, it's done by the legislator because the criminal code explicitly demands that there has to be a permanent harm to a body part for an injury to be considered grievous. But if you look at the Austrian implementation law of the EIO Directive and also at the German language version of the EIO Directive, you find that Annex D lists serious assault. So for all the German speakers, it's schwere Körperverletzung. And that was also transposed in the Austrian implementation law, but the Austrian criminal code knows several offenses that could fit this category. For example, section 84, which criminalizes the serious assault, and also section 85, which contains the offense assault occasioning grievous bodily harm. So the problem now is that for section 85 to be committed, the injury doesn't have to be serious for it to occasion grievous bodily harm. So it is completely unclear which quality of injury is required for the listed offense to be committed. So you can already see the problems in defining this offense in one member state, and it becomes even more varied when you compare different member states to one another. This problem also arises when you look at the offense illicit trafficking in weapons, munitions, and explosives, because there is no EU legislation that defines the term weapon, and there is no comprehensive list of weapons that are weapons in the sense of Annex D. And in their 2020 to 2025 action plan on firearms trafficking, the Commission even identified the lack of a common definition of the word weapon as one of the main hindrances in pursuing this offense. The second problem area I see is that sometimes the listed offenses are so broad that it is completely unclear which national offenses could fall under it. And it is therefore also unclear which national offenses you should look at when trying to find a definition for the offense. This can clearly be seen when you look at the listed offense computer-related crime. The term computer-related crime is really broad, and it's not really defined in EU law. There are several international sources of legislation that deal with computer-related crime. For example, the Convention on Cybercrime and also the Directive on Attacks Against Information Systems. But it is not clear which offenses are meant to be covered by Annex D, because the Convention on Cybercrime is way more broad than the mentioned directive. And under the Convention on Cybercrime, things like racist acts committed through computer systems or also computer-related fraud would be considered a computer-related crime. And that wouldn't be the case for the mentioned directive. So it varies in international law, and it also varies in the national laws of the member states which offenses they actually consider to be computer-related. And the same problem arises when you look at the listed offense counterfeiting and piracy of products. There is no definition in EU legislation, and it is also not clear what the intended difference between counterfeit and piracy products should be and what the term product means in the context of Annex D. And Furthermore, counterfeiting as a legal term is extremely broad. It ranges from counterfeiting documents to counterfeiting money to counterfeiting election results. So it is quite problematic from the viewpoint of the principle of legality, because it is not clear which offenses should be covered by this listed offense. And the last problem area, maybe the biggest problem area that I see, that there is a lack of criminalization of some of the listed offenses in certain member states. This is due because the EU, of course, doesn't obligate the member states to criminalize all the offenses mentioned in Annex D. Sometimes this is due because of the lack of an EU mandate to do so. Sometimes the EU just chose to not act on the mandates that they would have. But the result remains the same. Some offenses mentioned in the list are not criminalized in all member states. This can be seen when you look at the offense illicit trafficking in cultural goods, including antiques and works of art. We have the Convention on Offences Related to Cultural Property, which would require the member states to criminalize the illicit trafficking in cultural goods in their national criminal law. But that convention is not ratified and was only signed by 6 member states. So therefore, when you look at Austrian criminal law, there is no offense criminalizing the illicit trafficking in cultural goods. And unless the facts of the case amount to, for example, handling of stolen goods or money laundering, the illicit import and export of cultural goods is solely an administrative offense and not punishable under criminal law. On the other hand, if you look at Slovenia, there the criminal code includes Article 218 that criminalizes the illegal export and import of things of special cultural significance. So it is an autonomous offense in Slovenian criminal law. And the result of this is that if Slovenia were to issue an EIO concerning this offense, the Austrian prosecutors would probably have to execute this EIO for an act that is not even punishable under Austrian criminal law. And this causes huge practical problems and also a huge uncertainty in practice. I have spoken to several prosecutors that were all not sure on how they would definitely handle this situation. So you can see there's also quite a bit of legal uncertainty. So in conclusion, as you can see, all these problems pose a great potential for uncertainty and also judicial arbitrariness. There is uncertainty for the executing judicial authorities because they can't adequately assess whether an offense falls under the offenses listed in Annex D or not. And they can't check whether the classification done by the issuing member state is correct. And therefore, they can't adequately assess whether they should execute the EIO or whether they could refuse it due to a lack of double criminality. There's also uncertainty for the issuing authorities because they have problems in deciding whether a national offense they are dealing with falls under the listed offenses. And in return, there's of course also uncertainty for the suspect and the defense in applying potential remedies against EIOs. So in my opinion, the principle of legality can only be fully respected when a clear definition of each categorically listed offense can be found in EU legislation. And even if you agree with the European Court of Justice and assume that there is no conflict with the principle of legality, the list should still be revised if it were to be used in future mutual legal assistance legislative acts. Okay, and with that, I thank you very much for your attention.